Somebody, I don't care if it's handwritten, get me an order, counsel.
Yes, Your Honor, I attempted to, and I will make.
Oh I hear you. Get me an order. Get a piece of paper, write an order so I can get her assessed.
Oh, yes.
Right now, I'm done. Step away from my podium.
Get me an order. Somebody, I don't care if it's handwritten. The judge's voice cut through the courtroom, aimed directly at defense counsel. Get a piece of paper. Write an order so I can get her assessed. Right now, I'm done. Step away from my podium. The defendant hadn't said a word. She was standing at the podium waiting to hear whether she'd go home or go back to a cell, and the answer depended entirely on a piece of paper nobody in the room could produce. By the end of this video, you'll understand how a routine bond hearing can stall entirely over something as small as an email that never arrived. This hearing took place in a Michigan courtroom in the case of People v. Nicole Henderson. Henderson faced pending charges including an OWI matter from an out-of-county case and a separate malicious destruction of property allegation. She was represented by defense attorney Nicole Sadi. The prosecution was represented by an assistant prosecutor identified in the record as Mr. Cook.
I take it, Mr. Cook, that's why you are here today.
Yes, Your Honor, we're here for a pretrial bond review hearing. I was served a copy of that motion this morning. I was able to read through it. Most all the information in the motion, I believe, was already placed on the record, so I was already aware of all of this. So I'm ready for the on the motion. If the court wants a response, I'm fine with doing that hearing today if the court's inclined to do so.
The presiding judge had previously ordered that any bond reduction would depend on Henderson first completing a substance abuse assessment, and this hearing was scheduled specifically to resolve how and when that assessment would happen.
Person who is coming up to the podium now.
Your name?
Nicole Henderson.
Go ahead, counsel.
Your Honor, so this morning I did file an emergency motion in person regarding the bond. I'm not sure if you're able to hear that in the moment or schedule an immediate hearing on it.
Before this hearing, Henderson held a job at General Motors, a position her attorney described as providing resources unavailable to many of the other defendants that attorney had represented. She had a young daughter in her full-time care, with no other parent in the picture to step in. She had already been incarcerated more than 30 days by the time of this hearing. Her paid leave from work was set to expire that same week, meaning every day the assessment order sat unsigned pushed her closer to losing the job that supported her and her daughter.
General Motors.
The program through General Motors. There is an issue with Mr. Statman being able to assess her level of addiction, but those resources go away if she loses her job. This program hooks her up with...
But she's on leave, right?
Not for this week. This week is the week where it becomes, her leave becomes, she's expected to be back at work this week. Her leave is ending.
When did your leave end, ma'am?
I was supposed to return back Sunday night, July 6th.
Got it.
The specific cost here wasn't abstract. It was a job with real income, gone if the paperwork didn't move in days rather than weeks. The court's position, established at a prior hearing, was straightforward no bond reduction without a completed substance abuse assessment first.
I was informed that I tried to communicate with the court. Ms. Henderson had secured Mr. Statman's services to do a substance abuse assessment. We understood from what you said from the bench last time that you want to read the assessment prior to making any form of a bond reduction. The jail was asking in order for remote participation for an order from this court. I did attempt to send proposed orders to the court, but there is an issue apparently with my emails and not just being received through this court. So I will.
The prosecution's stated concern echoed that caution, with Mr. Cook noting the court's prior comments about serious health risks if Henderson were released without treatment in place, specifically the possibility she might harm herself or someone else, while still struggling with the alcohol issue underlying her charges.
My thought would be As the court indicated previously, we want to see substance testing. Obviously, Ms. Henderson has this OWI case, the out-of-county OWI case, as well as the pending malicious destruction matter. My concern is making sure that she gets substance abuse counseling. And from what I'm hearing, it sounds like that being done in custody is creating additional hurdles. I don't know. I spoke briefly with Laura. She indicated she may have a different individual who could do a substance abuse testing in custody. I'm not sure if that would be faster than for Mr. Statman to do a remote hearing with this defendant. I don't know the time frame on that, but I want to make sure that whatever way we move forward, so expeditiously to get her started with that counseling as soon as we can. Obviously, I think, as the court indicated, I don't know if it was last time or the first time that this case was up, there's some pretty serious health concerns for this defendant if she were to be released, and concerns about what she might do to herself with her substance abuse and whether or not she might harm or kill herself or someone else in the process of that substance abuse. So I just want to make sure that we are addressing that adequately before release. And I would be fine with whatever method that is, whether that's with Mr. Statman or with the individual that Agent Polaris stated. I'm happy to do whatever legwork I need to do.
The judge reinforced this directly, referencing statements Henderson had reportedly made that sounded suicidal in nature and expressing concern about her daughter's safety if Henderson were released without supervision.
Counsel, she's got a prior, a pending, and another pending. She was a .235 in this case. She was making comments that were, and I'm not necessarily qualified to say this entirely, but were of a suicidal nature of what she would do to herself, and that she just didn't care. That's where she was.
And she can be released into a treatment program with doctors and still get a substance abuse assessment instead of the detention where she's not receiving service.
This was not a hearing where either side was arguing Henderson shouldn't get treatment. Everyone agreed she needed it. The disagreement was entirely about how fast the system could actually deliver it. Most people watching this hearing miss what actually derailed it. Defense counsel testified she had already sent a proposed order to the court by email the day before, but that email, along with an earlier request for a remote hearing, had never arrived. She explained one of her email accounts had been compromised the previous week through a phishing link disguised as a party invitation, and she believed the court's copy simply hadn't gone through.
To hear.
I back up a moment, counsel. You sent an order to the court today?
No, yesterday, and I had also sent a request for a remote hearing on Monday, but I showed Ms. Wielding my emails. My emails were sent, they were not received. I did have a hack event last week through one of my email accounts. It was a party invitation that was not a real party invitation. I never should have clicked on. I thought I had secured the emails, but I believe Ms. Wielding didn't receive them. I didn't get a bounce back, so I'll have to correct that issue. But I wanted to make you aware that I've attempted some communications.
No bounce back notice, no confirmation, just silence where a signed order should have been. This is where a basic but frequently overlooked principle of pretrial release comes into play. Under Michigan court rules governing conditions of bond, a judge retains broad discretion to condition release on completion of specific requirements, like a substance abuse assessment, before modifying custody status, precisely because the court is balancing the defendant's liberty interest against documented public safety concerns already on the record. In plain terms, the judge wasn't refusing to help Henderson. The judge needed a specific piece of paper, an order directing the jail to allow a private assessor remote access to a detained defendant, and without that signed order, the jail had no legal authority to make the arrangement happen, no matter how much everyone in the room wanted it to. What followed wasn't cross-examination in the traditional sense. It was the judge, defense counsel, and a probation representative going in circles over the same missing document. Defense counsel explained she'd already paid the assessor, Mr. Statman. out of pocket, and that he could perform the remote evaluation within a day of receiving the order. The judge asked directly whether counsel had sent an order that day. Counsel said no the day before and reiterated the email issue. The judge asked whether the jail needed a written order specifically. Counsel confirmed yes. Then the judge asked the single question that mattered: how complicated can the order be? 1 page, counsel answered.
Okay. I just need to get her assessed. I just want an assessment and a report given all of the circumstances in this case. How complicated can the order be for Mr. Statman?
It wasn't. It was a 1-page order that I proposed.
Then can
Your Honor, would you like me to call Mr. Stanley?
And still, minutes later, that 1 page did not exist anywhere the court could act on it.
terms and conditions of her release so that we could get her out of here with something in place. But right now, as I sit here, I don't have anything in place. I'm at the exact same point that I was the last time we were here.
I need a written order, if possible, Your Honor, if you would consider it. She did pay Mr. Statman. Mr. Statman's schedule allows for a remote assessment.
Paid him
Yes,
already?
yes, he's been paid. It allows for remote assessment. The jail needs an actual written order from.
Here is what that gap actually meant in practice. Every hour spent debating why the email hadn't arrived was an hour Henderson's paid leave clock kept running down, moving her closer to losing employment before any assessment could even begin. What should have happened differently is procedural, not personal. Defense counsel, once aware of the email compromise, should have confirmed delivery through a second channel, fax, hand delivery, or direct confirmation with court staff, rather than assuming a sent email had been received, particularly given the tight employment deadline already on the record. The court itself, recognizing the recurring email failures affecting multiple filings in this case, could have established a backup delivery protocol earlier rather than only after the second breakdown. The cost of that gap fell entirely on Henderson, who remained in custody unassessed while her job security evaporated in real time over a technical failure neither she nor her attorney could fully control. There is no formal accountability mechanism for a lost email causing this kind of delay. No sanction, no review. The consequence lands solely on the defendant waiting at the podium. The prosecution's position throughout, delivered evenly by Mr. Cook, was that public safety concerns and Henderson's own documented risk to herself justified continued caution, and that any release plan needed the assessment completed first, regardless of the inconvenience. The defense's position was that the greater harm was certain, not speculative: job loss, loss of the private resources tied to that employment, and a daughter left without her primary caregiver, all while Henderson remained undertreated in custody rather than receiving care.
Go ahead, counsel.
Thank you. The truth is, Your Honor, while it is true that, it's appropriate for this court to weigh public safety concerns, even concern for my client herself, and what could happen, while that's appropriate, there's far greater harm that will happen here. It's not just a potential if she is incarcerated and unable to continue her employment. We are requesting that you put in an order that she immediately be assessed and follow the assessment done by the professionals. We can have Mr. Statman assess her, but he does not have access to those private services, which are actually, if I'm going to be real, they're superior to what community centers can offer Ms. Henderson if she were to lose her job.
The open question the judge alone had to resolve was whether continued detention, meant to protect Henderson and her daughter, was actually causing the very harm it was designed to prevent.
Question assessment.
All right. So the problem's going to be I'm now here at Wednesday. Her leave ended, you said Sunday.
And I know that this court is aware you could put her on an alcohol tether. She does have court in Shelby Township.
That has counsel. That's always been an option. The problem is the circumstances of this case, and I am doubtful to. I'm not changing my mind on that. I mean, she needs help. We can fashion something so that the public's not at risk, she's not at risk. I mean, the bottom line reality to it is that little girl that was here the other day, her daughter, I can't in good conscience let this defendant out where she may be traveling with that child.
The judge's response arrived not as a ruling on guilt, but as a demand for action. Get me an order. I don't care if it's handwritten.
You know what? I'm done arguing about it. I asked that something be done so that I could fashion something or be assured to let her out with as least risk as possible to herself or to the community. I haven't gotten that.
Your Honor,
now I'm here today, counsel, trying to figure out how to make it happen. And so we can keep going around and around. Well, you can keep going around and around because I'm stopping. I'm not going around and around about this. I told you what I wanted. I told you what I needed to try to assess it, to let her out safely. I will do that, but I need it.
Your Honor, may I have a written order denying the motion?
If you get me that order, I'll deny your motion, but get me the order that it gets her treatment, counsel. I don't know why this is so hard. Get the order.
May I explain?
Get the order.
In my email box, your court didn't. And
get the order. I'm done. Take her back.
When the hearing resumed shortly after, the judge confirmed a signed order was finally in hand, that Statman could conduct the assessment the next morning, and that a report would follow by early afternoon.
Court recalls case, People versus Nicole Henderson.
Morning again, Your Honor. Raymond Cook for the people.
Good morning, Nicole Shawty. I'm still present, and Miss Henderson is walking up to the podium now.
Hey, ma'am.
Nicole Henderson.
All right. We have finally received an order. I've signed that order. Mr. Statman has indicated, Ms. Claire, if I'm correct, can see you tomorrow at 10. The next question I had for Mr. Statman, which I think we got cleared up, is that he can then have a report by 1 o'clock tomorrow. Okay. And then what I'll do is I'll adjourn this hearing to July 9th tomorrow.
This reflects a basic principle underlying pretrial release conditions nationwide. Courts retain the authority to condition liberty on specific, verifiable steps precisely so that public safety and a defendant's own welfare can both be addressed before release, rather than after a preventable harm occurs. It's the same underlying logic behind conditional release frameworks recognized since Bail Reform Act era standards, balancing a defendant's presumption of continued liberty against documented, individualized risk. This case is not really about one missing email. It is about how much can hinge on paperwork that has nothing to do with guilt or innocence at all. Every American who has ever waited on a government office to process a form knows this particular kind of powerlessness, where the outcome that matters most depends on something entirely outside your control. Henderson's daughter, her job, and her own treatment all sat waiting on one page nobody could locate in time. Next was the delay in Henderson's assessment the result of one attorney's technical mishap, or is it evidence of a court system with no reliable backup process when digital communication fails? And if it's the latter, what would it take to make sure a defendant's liberty never again depends on whether an email happens to land in an inbox?